You're driving home after a long shift. Suddenly, those flickering red and blue lights fill your rearview mirror. Your heart rate spikes. You pull over, find a safe spot, and reach for your phone. You hit record. Before the officer even asks for your license, he barks, "Turn that camera off right now. It's for my safety and yours." What you do in the next 10 seconds determines whether you keep your constitutional rights or hand them over on a silver platter. Every single day across the United States, drivers make one catastrophic mistake. They comply. They apologize. They hit stop because they think cooperation equals safety. They assume that if a man with a badge and a gun gives a command, it must be a lawful one. But the moment that recording stops, your strongest witness disappears. Today, I am breaking down the 5 fatal mistakes drivers make when recording police, the exact Supreme Court and Circuit Court rulings that protect you, and the 4 magic phrases that will stop a rights violation cold. Mistake 1. Instant compliance with an unlawful demand. The biggest mistake is the compliance reflex. The officer approaches, sees the phone, and demands you shut it down. Most people comply because they don't want to make things worse. Here is the legal reality. You have a clearly established First Amendment right to record police officers performing their duties in public spaces. This isn't just my opinion. This is the law established in landmark cases like Glick v. Cunniffe, 2011, and Turner v. Driver, 2017. The courts have been crystal clear. A police officer cannot lawfully order you to stop recording simply because they find it annoying or because they don't consent to being filmed. When you are in a public space, and a public road is exactly that, the officer has no reasonable expectation of privacy. They are public servants performing a public function. The only legitimate reason they can stop you is if your recording is physically interfering with their duties. Holding a phone or having a dash cam mounted is not interference. The correct move. When the officer says, "Turn that off," do not argue. Do not get angry. State this exact phrase: "Officer, I am exercising my First Amendment right to record this interaction. I am not interfering with your duties." This phrase is a legal landmine for the officer. It puts them on notice that you know the law. If they arrest you after you say this, they are stripping themselves of qualified immunity, making them personally liable in a civil rights lawsuit under 42 U.S.C. Section 1983. Mistake 2. Handing over the digital vault, the Fourth Amendment. The officer realizes you won't stop recording, so they try a different tactic. "Give me that phone. I need to see what you've recorded." The moment you hand over an unlocked phone, your Fourth Amendment protection against unreasonable searches and seizures vanishes. You have just given voluntary consent to a search. In Riley v. California, 2014, the Supreme Court ruled unanimously that police must obtain a warrant before searching the digital contents of a cell phone, even during an arrest. Subscribe for more law advices. Your phone is not just a device, it is your entire life. Your bank records, your private messages, your location history. During a routine traffic stop, an officer has zero legal authority to demand your phone without a warrant signed by a judge. The correct move: if the officer demands the device, keep your hands visible and say, "I do not consent to any searches. You need a warrant to search my phone." If they physically seize the phone from your hand, do not resist. Physical resistance leads to resisting arrest charges. Instead, speak clearly for the recording and their body cam. "I am stating for the record that I do not consent to this seizure or any search of this device." Mistake 3. Failing to distinguish a request from an order. Police are trained in psychological command presence. They use phrases like, "I need you to step back," or "I need you to put the phone down." In the legal world, there is a massive difference between a request and a lawful order. Under Pennsylvania v. Mims, 1977, an officer can order you out of the car for officer safety during a valid traffic stop. However, they cannot order you to stop a non-interfering recording. Officers often phrase requests as orders to trick you into waiving your rights. If you comply with a request, the court sees it as you being a helpful citizen who gave up their rights voluntarily. The correct move: ask the clarity question. Officer, are you asking me or ordering me? If they say they are asking, you can respectfully decline. I prefer to keep recording for everyone's safety. If they say they are ordering you, ask, what is the legal basis for this order? Comply with physical movements, like stepping out, but continue to narrate. I am complying with your order under protest, but I am not consenting to any searches. Mistake 4. The self-sabotage deletion. This is the most heartbreaking mistake I see. An officer intimidates a driver, saying, "Delete that video right now or you're going to jail for obstruction." The driver panics and deletes the footage. By doing this, you have destroyed your only independent evidence. You have committed spoliation of evidence against yourself. Officers know that their body cam footage can be edited, lost due to technical glitches, or angled in a way that favors their narrative. Your recording is the only one you control. It is illegal for an officer to order the destruction of evidence. Several federal circuits have held officers personally liable for viewing, concealing, or destroying recordings. The correct move: be firm. I will not delete this recording. Deleting evidence is illegal. If you arrest me for recording, I will address that in court. In 2026, technology is your friend. Use apps that live stream or automatically upload to the cloud, like the ACLU's Mobile Justice or Simple Cloud Backups. Even if they break the phone, the evidence is already safe. Mistake 5. The contempt of cop escalation. You can be 100% right about the law and still end up face down in the dirt if you lose your cool. Courts give police a lot of leeway when it comes to disorderly conduct. If you are screaming, using profanity, or making sudden movements while asserting your rights, the officer will claim they felt threatened. On a body cam, a judge won't see a victim, they will see an aggressor. Officer psychology is built on scene control. When you record, they feel they have lost control of the narrative. This triggers an emotional response. If you match that emotion, the situation escalates to violence. The correct move: your tone must be calm, respectful, and definitive. Think of it as professional resistance. No sarcasm, no "I know my rights" lectures. Just the facts. When you stay calm while an officer is losing their temper, the recording becomes an incredibly powerful tool for your defense. It shows a disciplined citizen being harassed by an out-of-control official. The 2026 Action Plan, the 4 magic phrases. To protect yourself, you must move these phrases from your brain to your muscle memory. Practice them until they are automatic. When they tell you to stop recording: "Officer, I'm exercising my First Amendment right to record this interaction. I am not interfering with your duties." When they demand your phone: "I do not consent to any searches. You need a warrant to search my phone." When they give a vague command: "Officer, are you asking me or ordering me?" If it is an order, what is the legal basis? When they threaten you to delete the video: "I will not delete this recording." Deleting evidence is illegal. State-specific nuances. While the First Amendment is federal, some states have added extra layers of protection. In Colorado, the Right to Record Public Officials Act allows you to sue the police department directly for up to $15,000 if they interfere with your recording. In Arizona, a 2022 law tried to ban recording within 8 feet of police, but it was quickly struck down as unconstitutional by federal courts. However, remember the wiretapping trap. In 2-party consent states, like Pennsylvania or Illinois, some officers try to arrest recorders for illegal wiretapping. But almost every court, including the 7th Circuit in ACLU versus Alvarez, has ruled that wiretapping laws do not apply to police performing their duties in public because there is no expectation of privacy. Summary and closing. Your camera is your shield. Your words are the legal record. In the United States, we do not ask for permission to exercise our constitutional rights. We simply exercise them. The officer's body cam belongs to the government. Your phone belongs to you. Keep it mounted, keep it recording, and stay calm. If an officer chooses to violate your rights on camera after you have clearly invoked them, they aren't just breaking the law. They are handing you the keys to a successful lawsuit. If you found this breakdown helpful, hit the like button. It helps the algorithm get this life-saving information to more drivers. Subscribe to Expert Roadside Defense for more deep dives into the 2026 legal landscape. Stay safe, stay recorded, and never surrender your rights. I'll see you in the next breakdown.